you for tuning in again tonight. We have something really good, the hot topic in the news this week. This is a show where I try to educate real stories. Thank you for watching Truth and Justice with Vivian King. We've put together another exciting show for you tonight. It's a little different from most shows in that we don't have a person accused of a crime talking about his case tonight. Tonight we have famed local lawyer and sometimes international lawyer, Rob Fickman. Rob Fickman is going to talk about one of the problems in the court-appointed system and talk about solutions in which we can change things. He'll also give you examples of why we think this adversely affects the poor. I also have my very good friend and famed lawyer, Juanita Jackson, which some people might know as Juanita Barner, and I might mess up and call her Barner a few times during this night. But she's recently started working at the public defender's office. She's an assistant public defender, and she'll talk about the differences between our new system and the old court-appointed system that Rob is going to talk about, because we have both systems working right now. So we invite your calls, as always. Please call us if it gets interesting. Please try to stay on topic at 713-807-1794. So let's get straight into it, Rob. Talk to us about who you are. And Rob has a great new blog that he's sharing information with the public about the criminal justice system and current events. He's a very good writer, he's very informed, and he's trying to share his knowledge with you, so he'll be talking to us about some of those things tonight. So go ahead, Rob.
Well, Vivian, thanks for having me on your show, and happy to be here with Juanita. What do you want to talk about first?
First, I want you to talk about the way a court-appointed system should work.
Okay.
And how many cases a court-appointed lawyer should have, and the way our court-appointed system works in Harris County, because I know other counties might do it differently.
Okay. Maybe it's maybe the way to talk about it is how our system works, and then how it's supposed to work.
Certainly.
In an overview. And I've been practicing law in May. It will be 30 years. So I say 30 years, assuming I live till May. In Harris County, traditionally, what's happened is each court, as I was coming up as a young lawyer and trying to get appointments, each court basically had their own system of deciding how to appoint lawyers. We have in Harris County 15 county courts that handle only misdemeanors, and each one of those has their own docket. And we have, and of course you all know this information, I'm saying this for the viewers, and we have 22 district courts that handle only felony charges. Each one of those has an elected judge. So there's 37 judges in the criminal courthouse downtown that handle misdemeanors, 15 handling misdemeanors and 22 handling felonies. Every one of those courts historically has had their own method, if you will, of making appointments, and typically the appointments were made by the judge's assistant, which is called the court coordinator. If you've been to any of the courts, that's usually the person that resets the cases. Many of them are very nice people, many of the judges are very nice people. But the system historically was set up in such a way that they got to pick and choose who they wanted to do the appointments. Many problems with that system evolved. There was a lot of cronyism, was probably one of the biggest problems. People were appointed to cases in some courts who were not competent. In some courts, people were appointed because they were friends with the judge, not because of their knowledge of the law. So there were lots of problems historically with the court-appointed system. I want to be careful here and say, though, that that does not mean that all court-appointed lawyers stink, because that is far from the truth. We have, over the years, we have developed in Harris County a cadre, or a large group of lawyers that have dedicated themselves to defending indigents and poor people who are very good lawyers, great lawyers, I would say. people like Skip Cornelius and Danny Easterling and Joe Varela and just Vivian King and Juanita Barner and lawyers who really have dedicated a large part of their practice to defending people for a lot less money there than they probably should be paid, which was another problem in the court-appointed system, is that lawyers were really not getting paid what they should have been. So a number of years back, the Fair Defense Act was passed, which had pieces of it that were intended to make the system more fair and was supposed to create basically a wheel system in the courts where lawyers were picked once they qualified, let's say, to take first-degree felonies, that they would be picked randomly. So you wouldn't have just the judge's pals getting appointed. It would avoid the cronyism. And so let's say, just to make it a...
And just in case, so my viewers understand, cronyism are friends, okay?
Right.
So make sure you break down your terms.
Not just the pals of the judge getting the appointments. So an easy example would be, let's say you had a court where, let's say you have 100 lawyers in Harris County that are qualified to handle felony cases. And all their names would be on this wheel or this system where their names would come up an equal number of times, so the cases would be spread out equally among them. And that's what the Fair Defense Act, one of the things that it was intended to happen, so that each lawyer that was qualified and competent would get appointed to a certain number of cases. And the reason that makes sense is so that the lawyers are not overburdened, they're not given too many cases on the one hand, so that they can work and do an adequate job for their clients. And the other part is, just in fairness to the lawyers, so that some lawyers didn't get 90% of the cases, a small group of them, while other lawyers were left out in the cold, even though they were competent lawyers, because they were not friends of the judge. That was the intent, or part of the intent, of the Fair Defense Act. And what's happened is, since then, essentially the judges, many of the judges, not all of them, have essentially ignored it. And they've gone back to what went on before. Some of the judges have lawyers that are contract lawyers that work in their court, and that's a separate situation there. But by and large, what most of the judges do is they continue to appoint lawyers for whatever reason that either because of cronyism or whatever that doesn't follow the intent of the Fair Defense Act. So we still have the same problems that we had before. We have a small minority of lawyers handling a very large number of cases, more than anybody can humanly handle, and a large number of lawyers who are very good and competent lawyers who are not getting adequate appointments, and who would do a very good job for the clients if they were given the opportunity. And so...
Let me just interject there. One of the problems comes in that, say, if I do a very good job for someone and I go to court for a year because the person deserves to be found not guilty on a very major case, well, that judge might get mad and not appoint me anymore.
Right, or might cut your pay, right?
Might cut my pay. Many times I don't get paid. I never got paid for what I should have been paid for. Or a judge never, because I went to trial on a case, never let me work in that court again.
Here's what I think it boils down to. The judges... And I like most of our judges, and I think it boils down to this. The judges have in their court every day, they receive a...
Rob, do you mind let me take a call?
Sure, go ahead.
They've been on the phone for a while. Caller, you still there?
Yes.
Okay. Thank you for calling.
This is Vivian King. This is to Rob Fickman.
Okay.
Please, Rob Fickman, don't walk off the show like you did on... We need guys like you in Harris County. Thank you. Okay?
All right, thank you. He's going to say some good things, and I brought him here. I'm not letting him walk off, okay? So just keep watching and call us back, okay?
You chain him in. You chain him in.
I got him,
and
baby.
He's looking good and so forth.
I got him, baby. He's not going anywhere. All right, thank you.
That was more for dramatic
Thank
effect.
you. Bye.
That was unreasonable doubt. Here's the point I wanted to make, is that the judges have, and I don't know if you can get on this, Mark, but the judges receive in their courtroom every day something that looks like, I don't know if you can get that or not, but you can't. You can sort of see it.
It kind of looks like a graph. What he's showing you looks like a bar graph, so it's going to be tall bars and low bars.
And what they get is the judges get this thing that shows how many cases that they have. The judges that I've talked to in 29 years of practicing, I've talked to all of them, and many of them are still speaking to me, they somehow rate themselves by this crazy notion that they're doing a good job by keeping the number of cases in their court as low as possible, or the number of trial cases down. Now, it makes sense that any judge that has a constant flow of cases coming in, which there are, would want to keep some control over that so their docket didn't get to be 15 billion cases. That's on the one hand. On the other hand, the size of their docket really doesn't have that much to do with the quality of justice in their court. Exactly. The judges focus way too much on the size of their docket and moving cases. That is the judges, many of them, and of course I'm painting with a broad brush here, it's not all of them, but many of the judges focus primarily on the size of their docket. And because of that, these judges lean on lawyers to move cases. That's in misdemeanor court and in felony court. We see it every day. It's gone on for 30 years that I've been a lawyer. In misdemeanor court, you'll see, and we can talk about that later, but you'll see them bringing people out and pleading a whole bunch of people guilty on the very first day they've been appointed to the case. You see it in felony court, and what you see is these courts that place that make the size of their docket the most important thing. They reward the lawyers that move cases the fastest. If you move the case, you get more cases. If you don't move the case, you don't get more cases.
And Rob, let me say that another way. That means pleading people guilty when they're not.
That's
Everybody arrested is not guilty. And when you get retained clients, like I am fortunate enough to get a lot of, and Rob does a lot of, at this time, and Juanita used to do a lot of before she became an assistant public defender, you have an opportunity to reset a case and investigate the case, and then the majority of the cases might get dismissed. I mean, but you've actually investigated it, because police officers, while they do a very good job, they come to a scene and they just write down what somebody told them. The person could have been lying to them. So it's not the police officer's fault. And there are hasty arrests in Harris County. There are hasty filing of charges in Harris County. There is no lag time like in other smaller counties where there might be, say like in Fort Bend. Rob might get arrested tonight for domestic dispute, but it might take 2 months before the DAs look at it and decide whether they're really going to accept charges. And sometimes they don't. I might get arrested for injury to a child by spanking Morgan, which is a felony.
Good luck with that.
Which is, I know, she's big as I am. But in Harris County, they're just going to charge me right then based on what she said, and I have to fight it. And maybe I spanked her to discipline her, which the law allows. And but in other counties, they wait a while before they actually formally file the charges. So there's a big difference. So the problem is, if I'm poor and I go to jail and someone appoints me and they just plead me on the first day because they're more worried about, as a lawyer, working every day than whether I'm guilty or not guilty, then that's where we have a problem. And that's the problem we're trying to deal with now, is because we have an influx of people in Harris County that have criminal records that shouldn't have criminal records. And that becomes a problem with working, going to college, getting loans, living in apartments. It becomes a big problem.
One of the biggest problems, too, is on the other side, from the prosecutorial side. Moving cases, offering people plea bargains because they know the defendant's goal is to get out of jail. And there's so many in misdemeanor court, when I did misdemeanor appointments, of people, the facts didn't substantiate it, but ethically, if the DA makes an offer, we have to convey it to the client. And if they say, time served, the client would say, okay, I'll sign for it, even if you're not guilty. So that's moving a case. This person pled, the case is done, on the docket, off the docket. It happens more and more, and it still happens in felony court. They might not give them time served, but they throw out deferred adjudication like it's candy. And people get caught up in the system for so long, and no lawyering is really done.
No, and that's part of the
let's move to our next topic.
Can I add one other thing, though?
Yes,
about the judges and what is important to the judges, which is moving, a lot of the judges moving the docket. The judges and their staff are responsible in Harris County as it stands now, and it needs to change, for appointing the lawyers. And I suggest, and this is not just me, but there's lots of people that suggest this, there's an inherent conflict of interest in the judges making the appointments of the lawyers. Because the judge's agenda, it seems to be, is to move cases as fast as possible because they're concerned about their docket. Many of them, not all of them. Now, the lawyer's job in his oath, and these are two fine lawyers here, they know what it is. It's the duty in the oath that we take as lawyers is to zealously represent our clients and to support the Constitution of the United States and the state of Texas. The conflict is when the lawyer adopts as their goal not the fulfillment of their oath to their client, zealously representing their client and supporting the Constitution, but when they change their goal from zealously representing their client to adopting the goal of the judge of moving the docket. Therein lies the conflict of interest. The judge is appointing lawyers who are going to do their bidding, not the client's bidding, but the judge's bidding. And the judge is rewarding those lawyers. Now, we're not naive. We all know that's what happens, and they can deny it till they're blue in their face, and they do deny it till they're blue in the face, and they'll deny it to me, and they'll deny it to these wonderful lawyers right here, but it is what happens, and it's gone on for 30 years, and it's wrong. The lawyers who participate in the court-appointed system, by and large, are some great lawyers, but there are also lawyers there who have, in my opinion, seem to have adopted the judge's agenda rather than fulfilling their own agenda, which is zealous representation of the client. And therein lies the conflict of interest and why the judges should no longer handle the appointment of counsel. The appointment of counsel ought to be based on who's going to be doing the best job for the client's needs. That's what the lawyer's supposed to be doing, not for the judge's needs. Does that make sense?
Makes good sense.
Okay.
It makes really good sense. Let's talk about the list that we have tonight. We brought a list and talk about the list and what it is, and we're just going to kind of show you how it works. Mark has put the list up. Talk about what that is.
Okay, there's a commission in Austin, the Texas Indigent Defense Commission, and that's what TIDC stands for. There you go, Texas Indigent Defense Commission, and they work on issues related to just what it says, indigent defense. They do research, they put together statistics, and what they did in Harris County, and the list that you're seeing is the top of the 2011 list for Harris County. If you look at the list that's on the screen, you're seeing, and the names are not so much important, and we're not here to bash people, but what you're seeing at the top is juvenile cases, and the number underneath that is how many juvenile cases that particular individual handled in 2011 and had something to do with it. We don't know if it means they actually took it all the way to disposition or resolved it, but they had a hand on it because...
It does mean that. It says it at the bottom.
Well, no, I talked to them, it says it's not sure, because it's not clear on that, because I did talk to the people in Austin. It means that they handled it in some respect. It doesn't mean that they might have been substituted out, but they at least handled it to the degree that their name is associated with the case. They were on it at some point, but they probably weren't substituted out on that many cases. The second category is misdemeanor cases and how many of those that they handled during 2011, fiscal year 2011. The third category is felony cases and how many of those that they handled during fiscal year 2011. And the fourth category is really the most...
on those three categories, like on the first name that we're looking at, they did 255 juvenile,
right,
387 misdemeanors, and 278. What's the total?
Felonies. We totaled that up to 920 cases in 1 year, appointed cases in 2011 for that gentleman, not counting any retained business.
Right, and so and that category at the top says 4.1. What does that mean?
I'm going to explain that. What they did in at the Texas Indigent Defense Commission is they did some number crunching. They used standards that were developed by the National Advisory Commission. The National Advisory Commission, I have to back up and give a little history here. The National Advisory Commission is part of the American Bar Association, which is a very conservative bar association. It's the bar association nationwide. And in the 1970s, they did an investigation, and this part of it, the National Advisory Commission put together recommended caseloads, maximum caseloads for lawyers. And what they put together it was actually the National Advisory Commission on Criminal Justice Standards and Goals was the name of it. And they were appointed actually they started in 1971 doing research, and this is ABA, the American Bar Association. And what they came up with was certain caseloads. And the caseloads that they came up with were certainly flexible, but they were suggested caseloads for anybody who was doing court-appointed work, whether it's a public defender or a court-appointed lawyer independent. And the numbers were as follows. For someone doing felonies, exclusively felonies, it should be not more than 150 cases a year if you're doing felonies. Misdemeanors, excluding traffic tickets, it says per attorney per year is not more than 400 misdemeanors a year. That's still a lot of misdemeanors. Juvenile court cases, their recommendation was not more than 200. Mental health cases, not more than 200, and appeals not more than 25. And of course the numbers might vary somewhat from jurisdiction to jurisdiction, as I have a conversation with one individual today, these numbers are from the 70s. Cases, by and large, have gotten more complicated since then. We have more and more white-collar cases in the criminal law system, and so I would say these numbers may be, I would think in some jurisdictions they may be on the high side. But relying on those numbers, so the example would be if you have a lawyer that's doing appointed work or a public defender, if they're doing felonies, they should do 150, no more, or around that. But that means that's it. They shouldn't be doing misdemeanors, juvenile work, or anything else. Because 150 felonies, folks, is a lot. We were talking earlier, there's only 250 work days in the year. 150 felonies, you know, that's less than 2 days per felony.
And let me tell you what that is. Like on the first example we took, when this lawyer had 920 cases, I mean, he exceeded in every category. Like the felony cases should have been no more than 150. That's it. He did 278.
And what the number, and so we have 150 felonies, 200 juvenile cases, 200, if you're just doing juvenile work, it should be 200. Period. If you're doing misdemeanors, it says 400 misdemeanors, and that's a lot of misdemeanors. I mean, if you think about every single case, you've got an accused to interview, and some of those you're going to need to visit the scene, you're going to have witnesses to talk to. Even if the guy tells you that he's guilty, well, there's guilty and then there's guilty. Some people may be guilty of the offense, but there's what's called mitigation. A lawyer's still obligated to investigate whether or not the person has mental health problems, whether or not they had a reason they committed the crime that may reduce the sentence. So it's not just, I'm guilty, good, we'll plead you guilty. It shouldn't be that way. That is the way it is in Harris County oftentimes. But these numbers were established to set goals and reasonable standards for lawyers. And these numbers have been in existence since, as I said, in the 70s. The number on the far right column, and we looked at that list, that number says, this is the National Advisory, it's hard to read, but it says that's the National Advisory Commission's the number of attorneys required for this caseload according to their recommended maximum caseloads. Restated, what that means is, for the first individual, based on the 920 cases they have, that based on the national standards, it would take 4.1 lawyers to handle that many cases.
So one lawyer handled the cases of over 4 lawyers in 1 year, and that's
based
paid
on
for by
standards.
and that's paid for by a court-appointed system. And let me just say something,
tax
Rob.
dollars.
And that's our tax dollars. But let me tell you what that equates to. That equates to poor people feeling like they got messed over by a system, because they did get messed over by a system. That means that somebody handled your case, they talked to you too quickly, they pled you guilty, and maybe you weren't guilty.
You know, in some of these situations, the lawyer might have done a great job. I think, though, and like if you look at the second one, it's 3.5. That means it would take 3.5 lawyers to do that lawyer's work. As a practical matter, and then the next one is 3.2, then 3, and 2.8, and it's like take 2.8 lawyers to do that person's work. 419 felonies. And I don't think we need to keep the names up there.
And let me just tell you this. We'll take the list off, but if you want to see the actual list and the report.
That's public record.
It's public record, and Rob has a link on his blog to that public record. That's why I talked about the blog at first. But just to change this up a little bit, Harris County did start a public defender's office to try to address some of these problems. And Juanita Jackson is here to speak about the public defender's office because she's an assistant public defender. So Juanita, you're in the felony division. Talk to us about how your office is structured.
Well, we're structured and we adhere to the national guidelines.
The same ones Rob is talking about.
The same ones that Rob is talking about. Now, our office has an appellate division, a misdemeanor mental health division, and then we have the felony trial division, which I'm in. The goal of it is to give exceptional defense work to indigent people. Part of the problem that we have all seen, and we hear the stories of innocent people, innocent wrongful convictions. It was started to address that issue. It was addressing the day-to-day, even the more minor crimes, not necessarily the big murders. I mean, even though our office does handle cases like that, but to assure that they are getting the proper investigation, that they're getting the proper assistance, and that the cases are not under the guise of the courts, like what Rob talked about, that ultimately we're not at all tied to a judge. We're not at all tied to getting our money from a court, and we're not at all tied to limitations. As a court-appointed attorney, the standard is not only are they paid each time they go to court, but they have limitations. For a felony, the standard for a felony case.
Let me just interrupt for just a moment. What Juanita is explaining is the difference between if today there are two co-defendants on a case, say like in a felony court, her office handles, she can't handle more than 150 felonies per year, and that's it. She completely works for that office. She has a secretary. She has insurance. She has benefits, something I don't have. And say like two brothers commit a crime and they're both indigent, okay? Her office can only handle one case. They can't have two public defenders on the same case. So then the court might call me to represent the co-defendant. Now, she's going to explain the limits, what she can do, court appointment, because she's with the public defender's office with the resources, versus what she perceives that I could do, just court appointed. So talk about that.
So, for example, because I know I did both. I was a court-appointed attorney before I came to the public defender's office. The limitation is, the standard is, one, the court-appointed attorney has a set number of presumptive maximum of case settings. So the standard is, if you got charged with a felony, they presume that you need to have this case resolved in 5 settings. So this case needs to be resolved, or you have to ask the judge for more time or more money. And ultimately, you're limited. The amount of money that you're going to be paid on the case is pretty minimal. Then you also then have to ask permission as a court-appointed attorney to have an investigator assigned.
Whereas
and again, there's a limitation. The judge then says, the investigator is limited to investigating X amount of money, okay?
Which is $600.
Which is $600. Whereas what I have no limitations. I can thoroughly investigate the case. We have our own investigators. Each attorney, we have 6
Can you hold that thought? Let me take a phone call.
Yes, sure.
Thank you. Sorry for having you hold so long, caller. You're on.
No, it's okay. It wasn't that long. How you doing, Miss King?
Hey, Tracy Brown.
And Miss Juanita. Y'all got to be the prettiest whip I've ever seen before in my life.
Thank you.
Y'all made the courtroom look beautiful. And
what
how you
about
doing,
me?
Mr. Fickman?
Yeah. Okay.
Okay. This show, it's one of the best shows you had.
Thank you. Now, Tracy, what do you think about the court-appointed system? Because I think you have a little experience with it.
Yeah, that's what I'm going to talk about. I spent way back like in '82. I was convicted of robbery. I was only 17 years old at the time, and I had a club. His name, I don't know if I can say his name.
Yep, you can.
His name was Juanita Reyes. And they start we talk about the court appointed cross-out. I mean, that's a jailhouse term they use for a court-appointed lawyer. So you're gonna get crossed out. But anyway, the judge was I was at 178 District Court. Judge Hatton. That's probably before y'all probably started practicing law.
Judge Hatton, but we knew him as
I knew him.
Rob knew him, and I knew him as a visiting judge.
They called him Hanging Hatton.
He
said they called him Hanging Hatton. But you thought Fermentio Reyes did a good job with your case, right?
He did a very good job because everybody said, "Well, look, you going, I'm facing 2 to 20." And everybody said, "Well, you going to pen." So he came and said, "Well, Mr. Reyes," he said, "Well, I get you 8 years probation." And everybody said, "No, don't take the probation. Don't take that cross out. Don't take the probation." Well, took the probation, and even with the felony, I was able to bounce back, and I was wound up. I consider myself successful. I did pretty well for myself.
Well, I'm very proud of you, and you're a testament to a good lawyer is a good lawyer no matter whether they're court-appointed or not. And Fermentio Reyes is very well known. But that was '82, so how many years ago was that?
Right.
That's about 30-something years ago.
30-something years ago, and he did a good job. And that's when they could really kind of get away with murder back then, so you were lucky that he did. And I think that the people I've represented know that I've worked for them hard, and Juanita too. So, but thank you for calling in.
Thank you. They used to say, like, before you go to Hatton on Tuesday, they say he sent his wife and his son to prison for, like, some marijuana or something like that there. I don't know about that. But
I don't know if that's true. I don't know if that's true. I don't know if that's true, but they would make jokes about Johnny Holmes too, who was the DA that I worked for, and I found him to be a nice and fair man. I don't know if that's true or not, but I'm glad you got probation. I'm glad you successfully completed it, and I'm glad you're my #1 fan, Tracy. Thank you.
Okay. Well, I just want to tell people out there who are listening, there's life after court-appointed lawyers, and having a Southern, that don't really hold you back, you know, because I'm a homeowner, you know, I drive a brand new car, and I've been working ever since, you know, so I was given a second chance, and I still messed up even after that, but still, you know, God's good.
God is good. God bless you, Tracy. Thank you, baby. All right.
I
well,
think it's
let her just kind of finish this thought.
I was going to finish the thought to explain the difference. And the difference is there are limitations on the court appointed, and they're tied to the judge. Their money, their ability to properly investigate and defend is tied to the judge. In the public defender's office, there's no ties. I've never been limited in what I want to do with the case. I get to defend at any point. We can hire experts. That's another aspect that now things have changed. On a more serious case, we have DNA issues. We have all kinds of DWI, whether in toxicologists, et cetera, that ultimately, if you're a court appointed, you have to get permission, and very rarely is a judge going to give a court appointed attorney quote, monies and funds to hire. Very limited. I remember one time, usually limited on experts about $1,500. You can't find an expert that will come, review the information, especially on, for example, I have an intox manslaughter case. The experts that are needed, we need accident reconstruction experts. We need toxicology to look at whether or not the blood alcohol test was done correctly, et cetera. To be limited to $1,500, you can't even find an expert that will even sit down and talk to you for $1,500. So we're not limited by that in the public defender's office. We have our investigators, we have experts that we can call, that we can get funds for, that the county commissioner, we just say, we need this expert for this. I have mental health patients that I need to have reevaluated at all costs, so there are no limitations. And that was the significant difference. It came about when people talked about the district attorney's office has no limitations. They have been known in the past that these big murder cases that we see on trial, spending hundreds of thousands of dollars to prosecute a murder case, but yet on the defense side, they're limited to
$1,500.
$1,500.
And you have to go through a lot of changes with the judge to even give you that $1,500. Right. So that's
for example, the Andrea Yates, everybody talks about that. The expert in that case, the district attorney office, if I'm not mistaken, and I'm not misquoted,
it was a big number.
$100,000.
Over 100, I think.
And that testimony was questioned, too.
And then that testimony was questionable. So in the end, the public defender's office was created to even the playing field. And we are doing an excellent job, and you're seeing the difference. But the bottom line is we're still limited. You know, we have now, we're up to 13 lawyers in the felony trial division, and we're never going to be able to take on all the felonies, and it was not designed to do that. But we're just explaining the difference of why ultimately, and people are getting it. People are coming and calling, can you take our case, can you take our case? But we can't, it's still randomly done. We're still a part of the wheel system and the Fair Defense Act that Mr. Fickman talked about.
We're going to stop and take another call, and then we're going to go back to Rob. Thank you for calling Truth and Justice.
Thank you. This is Jesse again.
Hey,
How the three of you, before the show is closed, how can we change the system?
Now Rob is going to speak to that. We're going to speak to that tonight. And Rob is really an activist for this. So am I. Although my voice is a little slower. My voice is only through this production. But
no, I've been places with you.
Yeah, well, I do a lot of volunteer work in the city. But and Rob
is going to get the numbers and so forth. That's not.
But he's going to speak before. He's going to tell you. He might have an opportunity to speak before our legislators. And so he's doing. It's more that. It's interesting when you put information out in the stream of commerce, like this show, like Rob's blog. People start paying attention to it, and so that's the way the media works these days. So there are things that are planned. We appreciate you calling. Rob's going to explain some things that we can do.
And don't forget, the yellow that you're wearing is the color of optimism.
Oh, thank you, Jerry.
Harris County. Thank you. Bye.
Thank you, Jerry.
A couple things. One is I agree with everything Juanita was saying. The Public Defender's Office is really a good office, and it's led by Alex, who's who is somebody that was in private practice first, and went to work for the Federal Public Defender's Service, and so he had a great background to come in and start this office, and he's gotten a lot of really good lawyers like Juanita to come and work for the Public Defender's Office, and these are lawyers that are like Juanita who are dedicating their lives to representing people who are indigents and can't afford counsel. What's important, though, to remember, I think, here is that the Public Defender's Office is small. It's relatively small, and it will probably always remain very small. We have, and it's very important to recognize that we have lots of really qualified, competent, good court-appointed lawyers in Houston. When I'm complaining about the court-appointed system, I'm not complaining, none of us are complaining about the system in terms of all the lawyers involved with it. What I think we're complaining about here is the administration of it, exactly, and the fact that, by my count, we have in the first 2 pages, there's 14 pages on this list that was put together by Texas Indigent Defense Commission, 14 pages of lawyers, about 50 lawyers per page. The first 2 pages are lawyers that are getting way over what's the recommended number of cases. There's about 100 lawyers that take appointments who get more than one could reasonably probably handle. Some of them probably can, some of them probably can't, but if we look at the national standards, these lawyers are getting more than what the national standards recommend. Some of them as many as 4 times, 3 times, like we talked about.
Rob, talk about the solution.
Now, and I am. And my point is this, is that we have lots of lawyers out there. We have 12, this is 14 pages, we have 12 pages of other court-appointed lawyers, about 600 other court-appointed lawyers, many of whom are very well qualified, who are not being utilized by the court system. And who pays for that? And this is what leads to the solution. Who pays for that are the indigent defendants who are right now being represented by a lawyer that has 4 times the amount of cases he should have, or 3 times, or 2 times, because that's not going on in the PD's office. But the PD's office only has a very small percentage of the number of indigent cases that are out there. So if you have 100 people that are accused of crimes that are too poor to hire a lawyer, maybe the PD's office is only going to ever handle maybe 10 out of that 100. The other 90 are going to be handled by court-appointed lawyers in Harris County. That's the way the system is set up, and that's the way the system will continue. It has to change because we have a whole bunch of those 90 being represented by a very small number of people because of the way the judges have set up the system. Like we talked about.
My director's fussing at me because I have a lot of calls waiting. Let's take
let me get to the solution if you want.
One quick call, please.
Yeah, it's your show.
One quick call. Okay. Comment, please.
Lawyer King.
Yes, sir.
I'm a lawyer on a temporary leave of absence for medical reasons, but you and Lawyer Fickman are 2 of the finest lawyers, and y'all are both doing a great job, and Lawyer Fickman is really leading the charge, exposing some of this corruption in the judiciary about these court-appointed cases, and I want to commend both of you, especially commend him for taking the lead on this exposition of this corrupt behavior. All poor people are getting railroaded, and people like you and Lawyer Fickman are trying to do everything you can to stop it. So I just wanted to thank you and give you both a commendation for a verbal commendation for the good work that you're doing.
That is so kind of you to do that. And Rob is keeping us abreast with his new blog. So when his name comes up, his blog will be on there. It's really good. I pulled this report off of his blog. So if you want to see the whole report, he has it on there.
Well, it helps to have great mentors.
From one end to the other. I've even memorized part of that blog. I'm going to use it when I get when I'm medically able to go back to work.
God bless you, and we miss you. Come on back.
It helps to have great mentors. One of mine is a guy named Robert Pelton out there. Here's the solution, and it's been proposed, and it's in use in other places. The judges have to cede control of the appointment of cases because their agenda, whether they want it to or not, it taints the whole process, and it has for too long, and it leads to what you all saw on the TV screen. There's something that's called managed assigned counsel programs. It's in the law. It's provided for by law already. There's no new law needed. It's already there.
Is it in the penal code or the
It's in the Code of Criminal Procedure.
What's the section number?
It's in section 26.047.
And that's the same area of chapter 26.
That's where court appointments are all discussed.
The experts and everything.
And what it talks about, in short, is, and this is the proposed solution, and it will take time to get there, a judge in Harris County has to ask the Commissioner's Court to create a new agency. It doesn't have to be large, but an agency that's job basically is to implement the Fair Defense Act as it was intended to be implemented. This agency would be separate and apart from the judges. The judges would not control it. And you'd have like coordinators basically working in there, a small group of them, and they would handle the appointment of lawyers according to the will. And there'd be somebody that would be the director, and all this is provided for by statute.
So why don't we follow that in Harris County?
Well,
it's optional?
Because the judges
But is it an optional? It's not mandatory.
No, it's not mandatory. The judges have to agree to it. And so...
Now, let me ask another question. If we went to a system like that, does it also provide that they would do the payments? Because you couldn't let these random agency, a separate agency appoint, but then the judges still have to pay the vouchers. Because that would hurt.
It's a good question, and I'm not sure how that part works yet, but essentially, I believe that the appointment and payment would go through the same office. In other words, it would take the judges out of the equation. And it's similar...
The old accountant in me, an auditor in me,
right.
wants
and
to
it's
say,
similar
that
to
you
what
can't do that.
It's similar to what you have in federal court, where in federal court a magistrate clerk over here, and I'm nothing against them, magistrate clerk, they're very nice people, calls the lawyer and appoints them, like Vivian or myself, because we do federal appointments. And then we end up going to the district court and standing in front of the 11 or 12 district court judges. And at the end, we submit our voucher or our bill for our time, and the district court judge decides it, but actually it goes beyond them to a clerk that handles it, and we get paid whatever we submit within reason. So this system takes it away from the judges, and the judges, some are starting to embrace it because it's a pain for the judges to have to deal with this daily. If you have a separate office that deals with it, that takes care of making sure they have adequate court-appointed lawyers in their court to handle the court appointments that are there, and that these people are all meet certain standards of qualifications, like if they're Spanish, they need to be Spanish speaking, they have to take a test. And this office is headed by a lawyer. And you can also have, and it's provided for here, they have to be a budget, there's a program director, there's maximum caseloads are provided. They have to submit maximum caseload standards, which we don't have right now. In our court system right now, a judge can appoint, as you can see, a lawyer up to 900 cases. A lawyer could get 2,000 cases in a year if the judges want to do that. The only thing stopping it is the fact that it hasn't happened. It could happen tomorrow. So what we need is a different way of appointing counsel here, so that an independent agency handles the appointment of counsel, one that is not there to do the judge's bidding, one is there to make sure that the indigents in this city, the people that are too poor to hire lawyers, are given good, competent counsel. We have all those to pick from in this list that aren't getting cases.
Well, let me add something to that.
There's hundreds of people here that are not being appointed to cases that are very good lawyers.
But and maybe they don't want to either because they can't adequately do a case. But in addition to this independent agency should pay, this indigent agency should have a budget and also deal with the experts. Because the problem with a lot of difficult cases is that you have to have a good investigator and you have to have a good expert. And right now, if I do very few court appointments in the state system because we're too limited. I'll do them in the federal system.
Let me read you, and this is going to address a lot of your concerns. It talks about there has to be a plan submitted for it, and the Commissioner's Court would look at it, and the plan of operation would include a budget, a description for program director, maximum allowable caseloads for each attorney appointed under the program, provisions for training personnel who are appointed under the program, that's the lawyers, a description of anticipated overhead costs, a policy regarding licensed investigators and expert witness used by attorneys appointed under the program, a policy to ensure that appointments are reasonably and impartially allocated among qualified attorneys. Listen to that. Policy to ensure that appointments are reasonably and impartially allocated among qualified attorneys. Folks, we don't have that in Harris County
yes,
right
we
now.
do. Rob, wait. Yes, we do. We have the qualified lawyers because they take a test. So they're qualified, but it's the appointment that's wrong. And let me tell you, Rob, wait a minute, let's stop. One of the biggest problems, if you look at the list and you know the personnel is, people will leave the DA's office after 20 years, say number 12 on this list, and who were some of the toughest DAs there, and because they're no longer at the DA's office for whatever reason, retirement, got fired because of a new regime, then they become one of the top court-appointed defense lawyers. Do they care about the defendants? Have they changed their stripes?
Maybe they do.
Maybe they do. We never know.
Eventually.
But that's the part that seems unfair, is because it seems like it's just for money. So go ahead.
And I would say, Rob, to me, and I understand, and I support the idea of the managed system, but an easy solution to what we have now is putting limitations right now. Easy to do. We all know how this wheel works. Each attorney goes in and puts their name and throws their name on the list this week. But it's easy to program a lockout. You've already met your requirements. We can't use you anymore. You can't request anymore. You've already met your limitations. And that's easy to do. That's the easiest fix and an easy solution now.
Listen to this.
If there's the will to do it, there's not the will to do it.
It's not that easy. Let me tell you why. It's not as easy, but it can be done to where it's analyzed, because if you just do misdemeanors, it's 400. If you just do felonies, it's 150. But what if people are doing a combination? Then it's
just as they did
it could be
here.
computer. It could be.
But I'm just saying, but it's still a little bit more difficult.
But it's still,
the
now
computer
that we've
could do it.
gone to a
Juanita's
district
right.
clerk system, because if, for example, in our office, every month we get our numbers.
But you're only doing one thing. So I'm just saying what makes it a little bit more difficult is say if you got two. So basically, if they want to split it, they would have to have a maximum of 200 misdemeanors and 75 felonies.
The bottom line, everybody's got a spin number. They can spit out right now how many cases each person has. So we keep control in the district, not just
That's a
in the
solution
public
to the
defender's
numbers,
office.
but it's not a solution to the resources to defend the cases.
Right, but I think if the numbers were down, if they were limited, they would do better work. These are not bad lawyers. It's just the fact that they are taking on more and not doing an adequate job because of the sheer caseload. We want to believe that. And I think if you're limited as to what they can take on, then we will see better quality work.
I have a different take on it. I think
I have
some
a bit
of
of
the
a
lawyers,
different take too.
Let me tell you this. We've been around longer than you, Juanita, and some lawyers are never going to go to trial.
Right. I mean, I understand that. I was being nice.
Yeah,
and
you're
saying
being nice.
there's some people that if they're limited,
I'll put it this way. Anybody that's
they would
taken,
just have more retained lawyers and cases and plead them out.
I don't know how a lawyer can handle 600, 700, 800, 900 cases a year. In fact,
I don't know.
Well, I'll put it this way. I do know how a lawyer can handle that many cases.
Everybody out.
That is, they plead them as fast as they can get them. And we see this happening. This isn't some fiction that we've created here that we've just guessed that's what's happening. If you go to the criminal courthouse any day of the week and you sit in any the misdemeanor courts, you wait till about 10 o'clock, you'll see a whole chain of people coming out. Because what happens, and this is about the poor people you were talking about earlier, those judges deny the poor people PR bonds, and they're forced into the situation Juanita was talking about, which is you can plead guilty and get out sooner, or you can plead not guilty and have a trial in about 3 months. What are people going to do? They're going to plead guilty to get out of jail. And that's the worst irony of all. That is, people are pleading guilty to get their liberty.
We're going to talk about some real world solutions. So you do a lot of retained work. So have you ever had a client, Rob, that's come to your office, they want to retain you now, they can afford a lawyer, and you look at their priors and you try to figure out the range of punishment, your strategy, and you've seen that they were poor and just took a plea on an old case. Have you seen that?
I've had this situation, and I've had this conversation with our county court judges too, where somebody has never hired a lawyer before. Now they're coming to me to hire me on a misdemeanor, let's say, and they've had 2 prior misdemeanors, and they had court-appointed lawyers. And the day they got the day they went to court one day, they had the court-appointed lawyer that one day in the misdemeanor court, and they pled guilty on that day. Now, I'm going to be careful here, and I want to be very clear. That does not mean that every lawyer that does appointments in misdemeanor court stinks. That's not true. You cannot label all lawyers one way or the other. It depends on the individual. Some lawyers that do appointments in misdemeanor court are great, some aren't. But when you get into a numbers game, when you have lawyers doing hundreds upon hundreds upon hundreds of cases where they're doing 600, 700, 800 cases in a year, just on appointed level, not counting their retained cases, how in the world can they possibly do a good job? There's only so many friggin' hours in the day. Some cases I've had, and you have too, as well as you, and you just won a big case. Those cases, some cases take hundreds of hours before you even go to trial. So,
lots of investigation.
Right.
And one of the most frustrating things being a state court-appointed lawyer was basically having to investigate the case myself because the judge is not going to give me any money.
Right.
I mean, $600 is nothing. You need to spend at least $5,000 in investigation to investigate a rape case.
And
if it's a rape case or a burglary,
this goes way back.
It's gonna take hours. So basically, I have to do it, and I'm not gonna get paid for it, and I have to spend my whole weekend doing it.
For example, on one of the cases I'm on now, child pornography case, because it's so computer driven and computer experts, between me and our investigator and our computer forensics investigator, we've spent, and we haven't even set it for, we just got set for trial, well over 50 or 60 hours on
investigation. But could you have been paid for that when you would have court appointments?
Ever. And as a matter of fact, what is funny about this particular case...
Let me take a quick call. I'm sorry, y'all. This guy's been waiting for a long time, and we want people to keep watching. So thank you for calling, and what's your comment? Quickly, please.
I'm still here. It's not to you, the blue dress, your other guest.
Juanita Jackson.
I go back to a long line of lawyers, all right? How can we fix it? How can we fix the system? Tell the listening audience how we can fix it.
Well, Rob did by saying that we need an independent agency to administer the court-appointed systems. The lawyers are good because they've taken a test and they qualify. The problem is they take too many cases. So if we had an agency with these ABA rules fixed in there, like no more than 150 felonies, no more than 400 misdemeanors, or a combination thereof that fits with the rules, pay for the experts, which are the investigators, and also pay for the payments, that'll end the problem right away. Some counties are doing that, Lubbock and Austin.
It'll certainly improve it. I think there's two steps. I've got to answer your question. I think there's two steps. One is...
Tomorrow night.
Sorry?
Todd DuPont would love to have you there.
Okay, that's good news. There's two steps. One is I think we have to make sure that there's competent counsel on the court-appointed list. There are people on the court-appointed list that probably aren't competent. There needs to be a review. Just because somebody, and I'm going to disagree a little bit with my host here, just because somebody can take and pass a test doesn't mean that they're really necessarily a good lawyer.
And remember, Rob, there are people on this test list that never had to take the test.
We want you on tomorrow night.
Okay, well, let's
let me talk about that later. My point is this, is that we need to have a list that's comprised of good and competent lawyers, and my point is that a lot of the good and competent lawyers that are already on the list, and this is all three of us agree on this point, they're not being utilized, and the people that are suffering are the indigent defendants. The second part is if you have an independent agency that we've been talking about, and this is not unique, it's provided for in the law, that handles all the appointments and making sure that people are getting adequate training, that are doing appointments, and making sure that they have adequate investigators, and that's what the law is talking about there. And it's taking the court-appointed system and giving the court-appointed lawyers the same resources they would have, really, if they were in a public defender's office. But they're not public defenders. These are independent solo lawyers. They're not taking orders from anybody. They're not going to take orders from anybody at the top. What they want, though, is they need to be fairly treated, they need to be fairly paid, and they need to be fairly appointed. So you don't have one lawyer with 900 cases and another very good lawyer with 30 cases, which is exactly what we have in Harris County right now, and it's a disgrace.
Well, we have 5 minutes, and Ms. Barner, let me let you have 4 of it, and then I'll let.
No, I don't need any more. I've done.
Okay.
I took more of my time.
Try to answer his question. No, don't say that, but just answer the caller's question, because I think that summarizes it. What you continue to talk about what you think.
I think your idea of having an independent way that they can get funds. I think the bottom line is we have very competent lawyers that are here that are, quote, court-appointed lawyers, that if given the opportunity, that's why most of us that were court-appointed attorneys are now, people are vying to get a public defender's job because I came to the public defender's office to be able to do the things that I could not do as a court-appointed.
You wanted to be a lawyer.
For it.
I wanted to be a lawyer.
And get paid for it.
You don't want to worry about the judges cutting your pay.
I didn't want to worry about judges. And I wanted to be able to represent my client. And we're seeing it. The Harris County Public Defender's Office, in the short time we've been in existence, has had tremendous success. The same, the commission has just recently put out a report today commending the Harris County Public Defender's Office and the outcomes that we're getting. We have lists and lists of the cases we're getting dismissed, the acquittals that we're getting. Even in the old cases, we've had 4 cold case murders dismissed.
I mean, it's like they're a law firm.
And
they're a law firm. They're basically a law firm. They're basically a law firm.
It's like the Federal Public Defender's Office is the best federal lawyers in town, really.
Exactly.
Yeah,
I
they're
tell
the best in town.
my clients that you don't get just one lawyer. You get a team.
You get a team.
And we staff it as a team. We defend it as a team. We talk about cases. We strategize. We have investigators. We have experts. We also have, unlike other places, we have social workers that help people, not only the mental health people in a mental health caseload, but I can go and I can say, my client needs a great rehab. Help me find them one. Let's do these things. Things that ideally, as a court-appointed attorney, they need to have the same kind of resources through the kind of managed system that Rob has talked about. It can be done, and those are the things that can make a difference. The problem is, right now, the number of calls we get every day of people wanting the public defender's office. I had a call today. How can I hire you? It doesn't work that way. We wish that it could, and we wish that we could give everybody the quality of defense that we are giving them in the public defender's office. But as Rob said, it's such a small percentage. And it will only be effective keeping small. We don't ever want to be hundreds of lawyers. No. You know, because it won't work.
And it works well with the court-appointed lawyers, and it supports them. I want to say one thing, though, as an optimistic note here, because we've talked about how bad things are. I truly believe that the public defender's office has already impacted the system in a very positive way, and it will continue to do so. And I'm glad that it's recognized that it will continue to stay small for the reasons that we have all these great court-appointed lawyers out there in Harris County, which is very unique in a city this size to have this many qualified court-appointed lawyers that are available. But I think that the judges have ruled the roost here for so many years on this issue that this system will change. And it may not change this year, it may not change next year, it may be gradually, but what we see here, what we saw in these 2011 numbers, this is nothing new, folks. This is the way it's been for 30 years. This is the way, we're going to get to 2012 data, it's going to be very similar to this. It's going to be the same miserable disgrace. And the reason it's going to change is because there's going to be, I don't want to use the word uprising, but the community is not going to sit for this. As people get educated, as people see what's going on in the court-appointed system down there, which has been going on for so long, there's going to be change. And so I have a lot of faith that the people that are of good-minded people, like yourself, like both of y'all, it's going to change because we're exposing the ugly side of the system. And it's not to knock the judges that they're bad people. They're not. I think most of them are well-intentioned. But this system is wrong. And they need to focus on just judging cases and not be involved in the appointment business because of the conflict I referred to earlier.
Right. And I have a minute to just try to wrap this up.
Yeah. Thank you for letting me get that in.
Thank you, Rob, and thank you, Juanita, for participating. Callers, what I think, and viewers, what I think is that we need to fight to keep the public defender's office, fight for funding. You also need to all call your state representatives. If you look at your voter registration card, you can go to Harris County Votes, look up your voter registration card. You'll see who your state representative and your state senator is. Call them. Tell them we want to keep the public defender's office. We want equal funding for the court-appointed system. We want the managed care system in Harris County that is provided for in our Texas Code of Criminal Procedure. We want the system to be fair. If everybody out there, if we have 2,000 people watching and all of you call your state representatives, every year Rodney Ellis tries to propose new and improved methods. He's the one that wanted the court-appointed wheel to take it away completely from the judges. He's the one that pushed the public defender's office. But he can't do it alone. No. We need all of our state representatives to participate, the Republicans and the Democrats. It can't just be the Democrats like Rodney Ellis, because that's the lawmakers. So I believe, caller, if you say, what can we do? We can all tonight get on our emails and email our state rep, email our state senator, and tell them we want equal funding, and we want to keep for the court-appointed lawyers, and we want to keep the public defender's office, because there's always talk of it maybe not lasting, maybe it being a pilot program, but trust me, they are winning cases because they have resources and they're not afraid of the judges because they have a job. Like if I do a court appointment, I might not have a job tomorrow in a court.
And we want independent appointment.
We want independent appointment.
Court-appointed lawyers.
Well, we want it to be just like that, just like the rules say.
And it's not something bizarre. It's called the Managed Assigned Counsel Program. But what if you just
what is it? 26 what? 0.04?
26.047. This is state law. The state law already provides for it. So we're not. And in fact, it's already in Austin. They've got a pilot program. and Lubbock.
Lubbock
and we need a
Austin
pilot program here. Hopefully a year from now we'll have a pilot program, and some of the judges will go, you know what, we're willing to try this. We're willing to try something that will improve indigent defense. It's not about egos, it's about improving the system for everybody out there. And let's be proud of Harris County. We have a problem. Let's address it. Let's not put our heads in the dirt. Thank you.
Thank you for watching the show, and we appreciate you watching and your comments. Don't forget to read Rob's blog. I will have these shows on YouTube in about a week. I'm about 2 months behind, but I do need to send these.
You're working on your cases?
No, I've been working on cases. I have to reformat them with a web guide to upload them to YouTube. But please go to YouTube, look at Vivian R. King, no spaces, no dots, and I'll have all these shows where you can watch them whenever you like. Thank you for watching. Good night. Thank you for tuning in again. Tonight we have something really good, a hot topic in the news this week. He's been charged with crime. This is a show where I try to educate real stories.